I'll note that the Criminal Justice Act of 1964 is when we began paying for the defense. So the gentlelady is right that it's become critical, but it also, in fact, is not a constitutional right, is it? It's in fact something that our founders, for the first 200 years, did not think that paying for the defense was mandated, that in fact it's the result of a statute. So I hope the gentlelady would share with me that as we fund, we are funding something that we created in relatively modern times. With that, I'd like to ask a question from a budget standpoint. One of them is, your budget every year exceeds inflation in your request, doesn't it?
I don't know if it exceeds.
It does this year.
That is something certainly that impacts our
The
budget.
chairman of the full committee made it clear when he was asking those questions that you're looking at a 10, 12% request, and in some cases more. So if we give you the cost of living increase, nothing more, nothing less, are we cutting you, or in fact, are we baselining you? And in light of a $2 trillion deficit, do you think you have no reason to try to find ways to spend less to do your job than every other part of government? Is that a fair question?
We are very cost conscious, and the
No, I really, Judge, I've loved your testimony, but let's be, this is now straight budget. The court system has the same pressures we have, which is how do we in fact stop a government that is taking more tax revenue in constant dollars from the American people than we ever have before and still spending $2 trillion more than we take in? Do you believe that the court should participate to the greatest extent possible in finding those cost savings?
The court is very aware of that we are spending taxpayer dollars, and we do have a full subcommittee of the Budget Committee that looks for cost containment measures. We are looking at ways in space, because our space budget is $1.2 billion.
Okay, I'll take that as a yes, you agree that you should be. I asked you earlier about whether consolidating the various different services would help. I'd like you to take that back for the record, that in fact having 3 different sets of bureaucracy, if you will, for security, in addition to other subsets of your security budget, whether some form of consolidation would eliminate some of the administrative people. As the chairman said, we've got 677 or so federal judges, and plus senior status. The question is, are there overheads that can be cut while still fully empowering those judges? Today included cybersecurity, but I would be remiss if I didn't ask a rhetorical question, but it's an important one, it's a perennial one. If we took the money from PACER, instead of it being, for better or worse, the slush fund of the court, would you be championing, along with the gentlelady from California, that should be a free service? And in light of the fact that as Washingtonians, at times, every one of our museums is free to the entire public, and yet we charge to get the results of what is in fact a public record, the record of the court. Is it fair to say that one of the things that we should be looking at is the question of whether in a modern day, recorded information, which is part of the overhead of government, we have no choice but to record it, when the cost of delivering it has become less and less and more de minimis, whether or not we should be charging at all, and certainly whether we should be charging a tax that makes it a profit center for the courts.
Yeah, Mr. Chairman, thank you for the observations and the question. As you know, Congress has considered this before, and there's been quite a robust dialogue between the branches on
The
this.
Chief Justice chews me out every time we talk about it.
I'll leave that to him. And if Congress were to make the choice to make all documents for everybody, free, so to speak, it's not free in this sense. We, the judiciary, we still have to maintain those systems, operate them, and secure them. So there would need to be some alternative source of funding from somewhere to allow us to do that.
Okay. And you'd agree that the fact that the budget doesn't take a hit on the maintenance of PACER because it's a revenue source, but how much did you receive last year in discretionary funds as a result of PACER?
I don't know the answer to that off the top.
But it had a surplus which was spent on other things.
Yeah, all that money, as you know, it's governed by statute, and it's electronic public access funds, and there we invest it right back in the system to maintain it and to upgrade it, respecting the legal, limits of it.
So we can't take those PACER funds and use them, for example, for something in salaries and expenses or defenders. It's governed by statute what we could use those funds for. And a chunk of it goes back into maintaining and upkeep.
I've always heard about the chunk that goes back in, but I asked that question because, Judge Scudder, we're talking about cybersecurity. We're talking about PACER having been part of the leak of cybersecurity. And I asked the question of if it has surpluses, if the clear intent of Congress has been that you have discretion, but you have discretion based on the assumption that it's a reinvestment in the system, then when you ask for more money to modernize cybersecurity and when you opine that you don't have enough, should we be scrutinized? Is it fair for us to scrutinize where you've spent that money for the last decade and why the system is not more modern since it does charge its own fees?
Yeah, I see here, this is approximate, but in fiscal 24, we received about 150 million, 145 to 150 million in PACER receipts that way. And that is money that we absolutely today rely and depend upon to maintain and operate that, to provide the access that you're recognizing. So if it were, to dry up in whole or in part, we would absolutely need Congress's support with some stream of funding to be able to maintain that system so as to provide the public good that you're recognizing.
Well, and I'm not per se saying I want to make it free, although it is free to a lot of the users pursuant to the will of Congress in various ways. I ask the question because it will not surprise you that I've had more than a few of the prime vendors to government say, if you gave us that much money and told us we had to immediately upgrade the system and then maintain it, we could do it on monies similar to what you spend. And so there are competing factors who have said, you're maintaining a system, but you're maintaining it in the arcane old way. There are better ways to maintain it and ways to modernize it. And so, Judge Scudder, the question I have for you is, would you consider, in fact, the question of could we leap forward to a system that was substantially immediately at a best practices level if Congress could give you the authority to essentially contract and pay forward over a long period of time? Obviously, a long-term contract does require a commitment to the funding. That is something that's within the power of this committee to do, to in fact give you the ability to have a 20-year contract or whatever is be appropriate with a requirement that they meet those and future practices. Would that be empowering to you, since that's the reason for this hearing today?
Yeah, I would, Mr. Chairman, the effort to modernize and better secure our case management system is a huge priority right now and an intense one. And you're recognizing that with your question. It absolutely requires resources. We very much depend upon the Congress for that, and getting about the replacement of our current system and getting a modern, secure one that moves quickly and draws upon outside expertise to achieve that, we absolutely share that objective.
Good. Well, I think the ranking member and I will undoubtedly be talking about this. Earlier when Mr. Swalwell referred to, and I'm trying to wrap this up as quickly as possible, referred to his Marshall's Act. I want to make sure that, for the record, that you know that I took it seriously, that although, at least from this chair, I'm considering, in a sense, the opposite. I'm considering spinning off the marshals to DOJ and then consolidating all of your other needs and giving you the budget to do it. I do find an ambiguity between the role of Wyatt Earp, if you will, and the other historic marshals and many of the things that happen. Now, that doesn't mean that the marshal you trust today would not be transferred to your direct control and would somehow disappear. I believe the Marshal Service has a sort of a 2/3, 1/3 role, and we need to ask the question of, would it be more efficient to hold DOJ responsible for their portion, hold you responsible for yours, break out the budget in that way. And I've already, because of Mr. Swalwell's suggestion, spoken to the chairman and subcommittee chairmen of the conflicting appropriations to see if, in fact, they have a problem with it. And it was indicated they didn't. So I want to make sure you understand we are taking it serious. Mr. Swalwell came here to make that clear. And at least from my vantage point, he makes a good point. It may not be done the way he anticipated, but I would hope you would come back after consultation and ask the question of, can we do better with the three separate forms of security to give a single point of accountability to the process? And I think the answer you'll give us will be yes. I would recognize the gentlelady if she has a question.
I do not have a question, Mr. Chair, but I did want to enter a few things into the record.
I see you have your Constitution.
Yes, sir.
Without objection,
That
the
is-
entire Constitution